Good morning. My name is Tan Kai and my matrix number is 270907. Today, I will present our group 6 to introduce that we are going to present about the analysis regarding the offense of extortion under the Malaysian Penal Code. So, the extortion is the wrongful use of actual. It is also been defined as the practice of obtaining something, especially money, from an individual or entity by integrity or compelling arguments such as force, intimidation, threats, or any illegal powers. However, the exactions relates not only extortion, or the demand and accusation of something by force, yet to the infliction of something unpleasant like pain and suffering according to its precise meaning. So the extortion is sometimes referred to as shakedown or exaction. This is sexual because the extortion usually involves a threat to the victims or his property as well as his family or friends. The extortion can also involve the threat of violence or physical destruction, but it can also include the reputation harm or unfavorable government actions. The extortion is likely to be a criminal offense in most jurisdictions. Even though the robbery is the most common and fundamental kind of extortion, the delivering false threats to obtain an unfair commercial advantage is also a form of extortion. Moreover, the extortion can relate to the political corruption in the legal context, such as selling one position peddling infos, but in common use as the word it conjures up image of blackmail or the protection records. Hence, our presentation will focus on the main provision of the Malaysian Penal Code that pertains to the offense of extortion, and the benefits and disadvantages of the extortion regulation will also be discussed later. And in addition, we have some improvement to the regulation also been discussed in our paper. Yeah, that's all for me. I will pass to the next presenter.
Good morning, Doctor. I'm Liang Hui Ting, metric number 271841. Now I will be presenting the main sections governing the offense of extortion under Malaysian Penal Code. In Malaysia, the offense of extortion is mainly governed under the sections 383 and 384 of Penal Code. The extortion is defined in section 383 of Penal Code, which states that whoever intentionally put any person in fear of injury and thereby dishonestly induces the person to deliver any property to any person is said to commit extortion. The punishment for an offense of extortion is provided in section 384 of Penal Code. Once the accused is found guilty, he will be punished with imprisonment for a term up to 10 years, or with fine, or with whipping, or with any two of such punishment. The requirement to establish the offense of extortion is that the two elements, namely threat of injury and delivery of property, must be fulfilled. The threat of injury must be used by the accused to put the victim in fear of injury that the injury will be inflicted to the victim himself or to any other person. Subsequently, because of fear of injury, the victim has done an actual delivery of property to the accused or to any other person. If either one of these elements is not fulfilled, it will be considered as no extortion has been committed by the accused. To have a clearer picture on this, let me give you some example cases. In the case of Muhammad Taufik, the complainant had paid money to the accused, but there was no threat of injury used by the accused against the complainant. Since it only fulfilled the element of delivery of property, the accused therefore was not charged under the offense of extortion. While in Tan Chin King's case, the complainant did not give the certain sum of money to the accused, although he had been threatened by the accused. Therefore, the offense of extortion in this case was also not complete, as it only fulfilled the elements of threat of injury. In contrast, the Petasin case is a good case, which has provided a complete offense of extortion. In this case, the complainant had been threatened and subsequently paid a sum of money to the accused. Therefore, the offense of extortion in this case is complete. In short, to establish the case of extortion, both elements must be fulfilled.
Good day, everyone. My name is Chang Wen-Li, metric number 270799. It is notable that the law in regards to extortion brings a few advantages that give impetus to curb the offense of extortion more effectively. One of the advantages of the provisions of extortion is the scope of the term of threat to injury is widely covered. This can be seen in the provision of Section 44 of the Penal Code, where it defines injury as any harm, whatever illegally caused to any body, mind, reputation, or property. Therefore, the injury is not limited to physical injury, as it also includes harm to one's mind, one's reputation, or property. For instance, the complainant in the case of Bear Taksin versus R had taken a statement from the appellant as a threat to injury, where his property, the store, will be ruined if he did not hand over the expenses to the appellant. The element of threat to injury does cover a wide scope where harm to property can also be counted in the term of threat to injury. Moreover, the other advantage of the provisions of extortion under Malaysian Penal Code is the delivery of property is not limited to movable property. The term any property provided under Section 383 of the Penal Code encompasses both movable and immovable property. It has a broader scope since it includes any type of property, valuable security, or anything that may be transformed into valuable security. If someone attempts to obtain movable property, such as a house, by threatening to commit violence, extortion is said to occur. For instance, in the case of Hyderabad State versus Birapa, the court held that the property may include both movable and immovable property. Last but not least, the advantage of the provisions of extortion under Malaysian Penal Code is the delivery of property can be done to any person, not restricted to the person who makes the threat only. It means that it is not necessary that the person who extorts receives the extorted property. If it is mutually agreed between two persons, where the first person makes the threat to extort anybody, and the second person will receive the extorted goods, then both of the parties shall be liable of the offense of extortion. It is said to be an advantage that can give impetus to curb the offense of extortion more effectively, when an accomplice shall also be held liable of the offense if he contributes in the crime committed. For instance, A extorts C and B to receive the extorted goods from C. This is possible because it has been mutually agreed by A and B. Hence, both A and B are guilty of extorting C. Therefore, it is clear that it is not needed for the threat and the property to be made and to be received respectively by the same person.
Good day, I'm Liu Shisen with the metric number 270340. Now I'll be explaining the loopholes of the law of extortion. The law of extortion in Malaysia, in the context of threats made by public officials to exercise their legal powers, appear to be unclear and uncertain in scope. Based on Section 383 of the Penal Code as mentioned above, it fails to explicitly mention the liability for the threat to exercise or practice an authorized person's legal powers. Hence, these loopholes leave uncertain the legal liability of a person with legal authorities in threatening others to exercise his legal powers to obtain someone's money by force. The uncertainty in this context of liability for the threat to exercise legal power can be seen in several cases where the court decisions in these cases are uncertain as well. For instance, based on the cases of Vincent Lee versus Rex and Abu Hassan versus PP, the judicial decisions given by the judges in these cases is that the rule that the exercise of legitimate powers will never establish injury, and subsequently leading to the judgment that the threat to exercise legal powers by the accused does not constitute extortion. On the other hand, since the principle and court decisions in the context of liability for the threat to exercise legal power is uncertain, some of the opposing authorities were in the view that the threats to executions of legal powers does constitute the commissions of the offense of extortion. This may be seen in the case of PP versus Kang Siu Chong. By referring to these cases as provided above, it is obvious that although the circumstances of the cases were pretty much similar, where all of the cases involved the attempt to obtain money by means of a threat to exercise legal powers by an authorized person, the judgment of the courts were different. The uncertainty of court decisions in the context of liability for the threat to exercise legal power will lead to negative impacts on society, such as the impact of deterrence in relation to the offense of extortion is ambiguous. The degree of uncertainty that someone who threatens to exercise legal powers is actually guilty will lead to the failure to deter the offense of extortion, as the offender might like to take their chances to escape from the liability for the threat to exercise legal powers. Further, the uncertainty of the court decisions in the context of liability for the threat to exercise legal power bears the unfettered discretion to the decision maker as well. Since there is no guidance to the judges pertaining to the issue of liability for the offense of extortion when he threatens the others to exercise his legal powers authorized to him in order to get an amount of ill-gotten money, the judge is not constrained by point of precedent to hold in any case a fact that may leave him more defenseless to unprecedented impacts such as bias, corruptions, or prejudice that silently could steer the results.
Hello, my name is Loy Singh and my metric number is 271620. I will be presenting about how to improve or strengthen the law of extortions in Malaysia. So, as mentioned earlier, the governmental bodies such as the police officials can exercising the granted legal power to put a person in fear of threaten them for the use or investigations of a case. So, this person must be the accused of a crime to assist the police officers to find out the truth. So, any use of the threats they might be fall under the offense of the extortions would not be an offense unless this governmental body or police officials unlawfully use the granted legal power for their own purpose other than the investigations of the case, then the act will be held under the offense of extortions. However, in Malaysia, we doesn't have any specific provisions that provided for the offense of unlawful use of this granted legal power among the governmental bodies and police officials. So we should referring to our neighboring countries such as Singapore. They have added a new provision that stated about the unlawful use of these granted legal powers among the police authority will be held as an offense of extortions under their Singapore Penal Code. Same goes to United States. They have a specific provision under sections 872 of the Criminal Procedure that specifically stated that if a governmental body that conducted any unlawful use of the legal power granted by the law will be held as an offense of extortions, and the punishment will be opened up for the fine of no more than 3 years of imprisonment. So my suggestions, after referring to the above countries that have a specific provisions that provided for the offense of unlawful use of the extortion in their law, so there is no excuses for the Parliamentary of Malaysia not to amend by adding a new provisions that specifically stated about the offense of unlawful use of the granted legal power among the governmental bodies and police officials into our Malaysia's penal codes. And we think that it's very important for the Parliamentary of Malaysia to add a new specific provisions that granted this offense of unlawful use of the legal power among the governmental bodies and as well as the police officials. It's very important to uphold the constitutionality of fairness and the reputations of a government name. That's all. Thank you.
So in conclusion, Section 383 and Section 384 of the Malaysian Penal Code, it clearly determines the definition and also the punishment of the offense of extortion. For instance, Section 384 of the Penal Code entails the imprisonment of extortions for a term up to 10 years, a fine or whipping or any combination of these penalties if certain requirements have been met. Hence, the aforementioned law under the Malaysian Penal Code is believed to enhance and contribute to decrease the unlawful use of the real or threatened force, assault, or intimidation to get money or property from another person or corruption. Nevertheless, there is a loophole has been found during the research while the pertaining law did not provide proper guidance to the judges regarding the issue of liability for the offense of extortions, and this may lead to the defenseless experiencing unprecedented effect. After all, in our humble view, the amendment for the provision is stated for the Parliamentary of Malaysia in order to maintain the integrity of the name of government. And it could be accomplished by inserting a new provision or new illustration into the remaining law of Penal Code. That's all for us. Thank you.